what I want to talk about today has to do with your testimony whenever you testify in court. All right. When you testify in court, every single person who is involved in a custody case, if in fact it goes to a trial and or an evidentiary hearing when you yourself are going to present evidence, every single one of you will have to testify, regardless of if you have an attorney or not. Okay. Now, your attorney may have a sequence that they like to follow, but I want to share some tips with you that I use in my practice based on 20 years of experience plus my background in psychology and persuasion and the jury trial studies that I've done and things like that. And what it is it's a sequence that I usually like to follow. There's a few things that you need to know about it. Okay. Basically, when you first start to testify, especially if it's the first time that you've testified in front of the judge, you want to introduce yourself to the judge. You don't want to say like, hey, Judge so-and-so, I'm so-and-so. You don't want to do that. Like what your attorney would do is, could you please state your name for the record or something like that. So you get into your introduction, and along with your name, your introduction is also going to be, where do you live? Who do you live with? How long have you lived there? And I cover this in the program, but I also like to talk about some of the things that I've covered in the program on the weekly calls, just so I can keep it in front of you. But you go through that whole introduction. Next for the introduction part will be, what do you do for a living? How long have you worked there? What's your work schedule like? If it's relevant and or if you want to talk about it, you could talk about salary, right? Then you get in, even though obviously the judge knows you have kids, you get into the children. Do you have children? Yes, I do. Do you have children with Mr. or Mrs. So-and-so, the defendant or the plaintiff? Yes, we do. How many do you have? I have 3 boys. Their ages, 12, 9, and 6. You can get into the details then about the children. Where do they go to school? Okay. What grades are they in? What's their schedule like? Are they in any activities? Do you participate? You're going to introduce yourself, your background. You're going to introduce your family, their background. And then you're going to start hitting on topics that are important for you. What I like to do personally on direct testimony, which will be your testimony, is I like to try to keep it as positive as possible. Okay. That being said, if there's major things that you need to talk about with regard to the other party, you can talk about them. But in my opinion, the most effective way to bring up the negative portions was during cross-examination of the other party, right? So when you're talking about the positive portions of your case that you want to show, why you should have custody, why you should have more custody, or more custody than the other party, or primary, or whatever you're seeking. There's a specific sequence that I like to follow. And what I would do is once I get through those introduction periods, then I get into, say, a chunk of like a favorable issue or a favorable evidence that I want to present, that I try to keep it grouped together per issue, right? So if let's say you're trying to say like that your house is better equipped for the children, well, then you would get into the house. How many bedrooms do you guys have? Do the kids share a room? Do they have their own room? Do you have a yard? Do you have a neighborhood? Do you have kids in your neighborhood? All that kind of stuff. And then you move on to the next favorable section, right? And in the new program, just to break in real fast, in the new program, you're going to see one of the really cool documents that I like in that new program, the Custody Case Mastery 2.0, and you've seen me posting in the private group about it. One of the really cool resources that I like is a document that I created called the Custody Case Evidence Evaluator. It basically explains to you exactly how I personally have evaluated what evidence to use and what not to use in my trials over the course of my career. Okay. And when you're doing that, when you're doing the positive section, one of the things you want to talk about, and I talk or know about, and I talk about this in the program, is the psychology of persuasion sequence. And what you need to know is that what people hear first they remember best, and what people hear last, they remember first. Okay. So through your, you want to remember that through your entire testimony as a whole. So you're going to want to hit something important at the front and something important at the end. And you're going to want to remember that, okay, Hope, if you submitted your email, you can submit it here now, your email address, and I'll see if I sent you an invite. If you already submitted the email, I probably did send you an invite. Some of the invites are going into your spam, so double check your spam. But if not, you can drop your email again and I'll do it later tonight or tomorrow morning. But so you want to look at the sequence as your testimony as a whole, and then during each category that you're covering for the judge. So like, say that you're covering a positive category here, you would want to make sure that the first thing that you talk about is, you talk about something important first and something important last, right? Because what the judge is going to do is they're going to be hearing your testimony as a whole, and then it's just human nature to chunk out or fragment portions of that testimony, if that makes sense. Another thing that you can do that I really like to do is if there's something coming up, because judges are really good with like paying attention and things, but they're also humans too. So you can't guarantee that they're going to be sitting there paying attention and listening to every single thing that you're saying. So if you're about to hit a topic that is incredibly important, and you want to make sure that the judge hears it, you can either have your attorney something like, okay, this is okay, this is very important. I want to you make this clear for the court. If you don't have an attorney, or you just want to chime in, you can, what I would do sometimes is you can use the art of silence. Because if you ever notice when you're in a room and someone's speaking, and say that someone's speaking and like you're sitting there like taking notes or something, or like you're listening, but you're kind of not listening, but you're writing on paper or doodling or something, and then all of a sudden there's dead silence. What does like everybody in the room do? They all like look up, right? So I've used that many times, particularly in jury trials, where if I see a judge like not paying attention, maybe they were writing notes and taking notes, and then all of a sudden they look like they're kind of zoned out. I'll use the art of silence to try to regain attention from either the jury or the judge or whoever. Okay. Another thing that you can do is, you can, it might be objectionable because it's like an asked and answered type thing, but you can try to like repeat what you say too, or repeat it in a different way to make sure that the judge understands it. Okay. Those are just some tips that I wanted to share with you to bring back to the forefront of your knowledge base, because it's very important. And I recommend, if you haven't already, I recommend going through all of those sections on like direct testimony, cross-examination, the direct testimony of an observation witness. Those would be people like friends or family that have seen you interact with your children, or a babysitter that has seen you, like anything like that. But get through all of those, because regardless of if you have attorneys or not, if you guys are going to be going to hearings, you're going to want to make sure that you know how to handle all of that stuff. And it's all very good material. It's stuff that I've learned and used through my years of practice, and it's stuff that I've learned from sitting on the bench too, and seeing things from the other side of the bench.